It's a good night for Open Line and a good night to take your questions. We are talking about renting and homeowner rights. And I know you have questions because we get calls all the time into the newsroom about people in some pretty tough situations. And we usually say, call legal aid. Well, tonight our guest is from the Legal Aid Society. Zac Oswald is joining us tonight. Zac, again, thank you for being with us. We have a lot to talk about. You've already given some great information about rent relief programs. We will continue to do that. So if you missed it at home, grab pen and paper. We will circle back to that here in the next couple of minutes. But Zac, I want to talk about the eviction process. It happens, but how does it happen legally, and what are some places where things go wrong?
Yeah, so the eviction process is interesting in Tennessee because there are really two different sets of laws that apply to tenants in Tennessee. And the first is for population counties with populations of 75,000 or more people, minus Putnam and Greene County because of some recent legislative changes. But if you live in a county where the population is 75,000 or more, you're going to look to what's called the Uniform Residential Landlord Tenant Act. And if you're in a rural county, a smaller county, you're just going to look to one specific law that tells you how long the landlord has to give you before you have to move out. But if we break it down statewide, what does the eviction process look like? It's really a four-step process. The first is that your landlord has to give you notice to say, I am terminating your lease, I'm ending your lease on X day. And depending on the reason why your landlord's ending your lease, they may give you a right to cure, meaning that you have a chance to make up or fix the thing that you've done wrong. Again, I want to point out the difference between those counties with 75,000 or more people. If you live in one of those counties, your landlord can actually put in the lease that you waive your right to notice for non-payment of rent, and that means that the landlord can jump straight to step two. What is step two? Step two is filing a lawsuit in court to start the eviction process. And that would involve a tenant getting served with a paper called a detainer warrant. We often have people that call us and they're worried because they get a paper called a detainer warrant and they think that they're going to go to jail or something along those lines. That is not what that means. It's just a historical name for the paper that starts the eviction process. Step three is actually your day in court. That's your day to tell the judge, this is what has happened here. These are my defenses. This is why I should not be evicted. And if you miss that court date, you lose automatically. So it's always important, if you get a court date, go. And then the fourth step is when you're actually physically removed from the property. If you lose in court in Tennessee, the judge actually still by law gives you 10 more days before you can be forced out of the property. But after those 10 days expire, so today's July 18th, on July 28th, after that, the landlord can actually ask the sheriff to come and help forcibly remove you from the property.
Do steps 1 and 2 happen simultaneously?
That's a great question. No, they do not. Not unless it's that tenant who's waived their right to notice, then we're really jumping to step 2. But step 1, that notice of termination, is usually going to be a 3-day notice, a 7-day notice, a 14-day notice, or a 30-day notice, depending again on the reason why the landlord is trying to evict you. And only after those days expire can the landlord file the lawsuit in court with step 2.
And does there have to be some acknowledgement from the renter that, yes, I have seen this, I acknowledge that this is happening? Because I just recall one case, and I don't know all the details, but the woman came home and deputies were moving her stuff out of her house. She said, I had no idea this was even happening. So clearly she missed the court date. Do you have to acknowledge that you have been served?
Yes and no. So the important thing for that would be, Carrie, that if the tenant is not served with any of those things, to let people know as quickly as possible that they didn't know that it was happening, and there are potential defenses that exist there. If the tenant wasn't given a notice before the lawsuit was filed, or if the tenant didn't get the lawsuit before it went to court, that may be something that might be able to reverse the eviction. Those cases are really difficult to argue in front of judges, and so those are really cases where you need to find an attorney and you need to call legal aid as soon as possible to see if we can try and reverse what has happened here, because there's also that 10-day deadline for you moving out before you before the landlord can force you out. That's the same deadline that legal aid would have to be able to intervene in your case before it becomes final. And so if we don't catch it within that 10 days, it's very, very limited what we can do legally.
Wow. Okay, let's hop to the phone lines. We have Betty on the line. Betty, thank you for breaking the ice tonight. I know we'll get more calls after you, so go ahead with your question.
Yes, I'm calling about affordable housing, these apartments that they have just put up, and people are moving in them, but they're in the apartments less than 6 months, and they're going up on their rent. Is that legal? And people that live in the apartments, some of them are on Section 8, and they're not going up on their rent. Is that legal?
Good question. Zach, could you hear that okay?
I can hear it, Betty.
Okay,
Thank
Betty,
you.
I'm going to hang up because it's easier for you to hear if you listen to the TV. Is that okay with you?
Sure, that's fine.
Okay, you listen to the TV now and we'll get Zach to answer it. Thank you for calling in.
Okay.
Okay.
Bye-bye.
All right, Zach, go ahead.
Yeah, I'm going to start with the general rule that Betty kind of asked about, and that is, I'm in the middle of a lease agreement. Can the landlord raise my rent? And the general answer to that is no. If you've got a lease agreement that says these are the terms, which include how long I get to stay here, how much I have to pay each month, that can't change until the lease is over and you guys are negotiating a new lease. What Betty seems to be referring to, she said affordable housing, is a program called the Low Income Housing Tax Credit. And that is a program where the government essentially gives tax breaks to developers who agree to build affordable housing units in exchange for basically these tax breaks. So those rules that Betty is asking about are based on the IRS laws, actually, and those laws do say that they can change the rent when HUD changes what is called their fair market rents. And so if HUD changes the amount of money that they consider fair in the Nashville area, the landlords of LIHTC, those tax credit properties, can raise the rent to match it. And I apologize if I didn't explain that well. It's a really difficult process because it involves the IRS.
Yeah, nothing's easy with them. Well, let me ask this question, and maybe you have already answered it, but what I heard Betty saying was that within her building there are Section 8 properties, tenants, and so they are raising the rates on people who are not the Section 8 folks, but they're raising the rates on the other people. Is that legal? That you have different rates throughout the building?
That's Carrie, that's a good distinction to point out. So the people that are on Section 8 are living in units that may be subsidized by Section 8. Those are HUD units, and in the Department of Housing and Urban Development, their structure usually bases the rent amount on somebody's income, and HUD is actually paying the difference. And so the rents are going up for those tenants. It's just that HUD is covering the difference, and that's why the Section 8 tenants aren't seeing an increase in their rent, is because they are being covered by a different program.
Good information. Okay, Jay is on the line now. Good evening, Jay. Go ahead. Jay, listen to your telephone, not your TV, or you'll get that crazy delay. Go ahead with your question, Jay.
Yeah, I was almost scheduled with my question.
Okay, go ahead. We're listening.
I was concerned about like roofing. Are you do you understand about roofing and insurance companies?
Are you in a rental property?
No, doll, I'm in a home.
Okay. Zach, is that something you would be able to answer, is talking about roofing companies for a homeowner?
I think the best suggestion for Jay tonight would be to go ahead and call Legal Aid Society. And Jay, I'll give you that number now so you can watch it on the broadcast. It's 1-800-238-1443. And you can also go to our website, www.las.org, to see when we might have a clinic where you could ask somebody about roofing and insurance issues.
Good deal. And Jay, we're going to continue to give that information. Actually, it's on the bottom of the screen right now. So if you grab a pen and paper, we will continue to put up that information. Give them a call in the morning or go to the website and we'll get you fixed up there. But yeah, tonight we're mainly talking about renters' rights, some homeowners' rights, but really we're focusing on renters' rights. That is Zac's specialty. That's where he just came out of, even though now you're the big senior deputy director at the Legal Aid Society. So we were talking about the eviction process and getting into some of the nitty-gritty about that. I do want to talk, I mean, it's never a pleasant process to be evicted. What are a renter's rights if this starts to pop up? What can they do?
Again, the first thing that we see that leads to evictions is tenants not showing up to court. It's important to know that if you don't go, you get a default judgment against you, which means you lose automatically. And so it's important to show up. And I know that that's frustrating. We've got courts across the state that start at 8 o'clock in the morning, 9 o'clock in the morning. And for somebody who needs to make it to court to be able to maintain stable housing, and they've got to worry about childcare issues. They've got to worry about whether or not they can get off of work for court, all of those sorts of things. It is easier said than done to show up for eviction court, and I think that's what people don't often understand is they think, oh, a judge made this decision, it's the right decision, this person needs to be evicted. But a lot of times judges are making decisions without the tenants ever showing up, and they're making decisions on dockets that are 100 and 200 cases long. And a judge is making that decision in less than 5 minutes. It shouldn't be a game show to save your housing, but it really does function that way in our general sessions courts sometimes.
Can you kind of set the scene for me? If somebody gets the notice, obviously you're saying you've got to show up, you've got to do everything you can to show up. Do you have to hire a lawyer? Because, I mean, just going to court can be intimidating, not to mention the hurdles that we've mentioned. But then you're like, well, where do I even start? I'm not a lawyer.
Of course, it's best to have an attorney, but we did, or actually Vanderbilt did a study that showed in Nashville that about 98.5% of landlords were represented by attorneys when they went to court, and less than 1% of tenants to this time were represented by an attorney, and that's unfortunate. So it's important for people to get the help that they can, whether or not that's going to Legal Aid's website and finding the renters' rights brochures that we have on there. And again, showing up is battle number one. Being strong in your convictions and saying, this is why I should not be evicted, this is why this is wrong. If you don't have an attorney to represent you, is the second thing that you need to do.
Okay, we're going to take another quick break. I invite you to call in. Get on the lines right now, 615-737-PLUS. If you have questions about your rights as a renter, this is the time to get them answered. Stay with us.